Well, welcome. I want to thank you both, Sharon and Ken, for choosing me as your mediator today and for agreeing to appear here. I understand from the terms of your contract that there is an ADR clause in place and that you have chosen mediation today to try to resolve the dispute that is in front of you. A little bit about the process today. You are working under the ICC mediation rules, and the parties have requested that our mediation remain confidential today. Is that right?
Yes.
And that's fine. Anything that you say here today will remain here today. If I take any notes, I'll destroy them when we're done, as long as everything comports with local rules under the ICC. So I don't anticipate any problems with that. So you should feel free to speak frankly with one another.
Okay.
A little bit about the mediation process, as you're both attorneys, I'm sure you're familiar, but I am here to help you with the process, and the two of you are responsible for the product. Any agreements that you reach today are ultimately the responsibility of the attorneys and the authority your clients have given to you. So I'm not here to make decisions, I'm not here to make suggestions, I'm here to make sure the process runs smoothly and that you both get a chance to say what you came here to say. If there is a possibility to reach an agreement today, we might write that up, but again, that is up to the two of you and how things proceed. I might from time to time check in and make sure that we're moving along as, that we're using the time as efficiently as possible and that we're talking about the things that you came here to talk about today. And if I feel like the process isn't productive, I might ask that we meet separately. I would meet with you, Ken, and then I would meet with Sharon or vice versa and make sure that we each have a chance to, you can speak freely with me if you feel that that would be helpful, and you could also request a caucus if you feel like that would be helpful today. All right, before we begin, I would just like to remind you that because I'm not a decision maker, you don't have to convince me of anything today. So really you're here to talk openly with each other, and so I encourage you to talk directly to one another as much as possible, and I'll give everybody an equal chance to share what brought you here today and what you think might be helpful moving forward. So, Ken, I understand that your client is the one who has made a demand and requested a response from Sharon, is that correct?
Right.
Okay, so why don't we start with you and you can just tell me from your perspective what the issues are that you would like to resolve here today in mediation.
Sure, thanks, Lynn. And first of all, I appreciate, Sharon, your agreeing to come. Lynn, for your information, I'm in-house counsel for Shenzhen Nouveau. We are a high-tech manufacturing company with our headquarters in Shenzhen, China. About 6 months ago, we entered into a contract with Zig Incorporated. It's an exclusive manufacturing contract to produce both hardware and to install software related to some technology that Zig created to produce a tablet scanner. And Sharon, I just want to mention to you that we have enjoyed working with you. It was a very good negotiation to create this business relationship. We look forward to resolving this in an amicable way so that as we move forward, we will continue to have an ongoing and good business relationship between our two companies. One of the provisions of this exclusive manufacturing agreement is a provision in the event that that Zig Incorporated were to produce or develop similar technology or new technology related to what is covered under our agreement, and specifically it's provision 17.2 under the contract. And that provision provides, it's pretty straightforward, that during the term of this agreement, and we are under a 1-year agreement, we're about 5 months into that agreement, that in the event that during the term of the agreement, Zig requires the manufacture of any new product or manufacturing, including but not limited to tablet scanners, that they're more than welcome. They're free to solicit bids from any company that they choose. But because we are already in a contractual relationship to manufacture this kind of product for Zig, that pursuant to the contract, we would be given an opportunity to review whatever bids they receive for this new technology or this new product development, and we would have an opportunity to submit our own bid. And in the event that we are successful in submitting a bid that exceeds the requirements of any other competing bid, that the business would come to us. And frankly, that makes perfect sense because we have worked very hard together. This is a new product area, and we recognize the intellectual property of Zig Incorporated. But quite frankly, Shenzhen brings to the table the expertise in translating ideas into products that can be sold to consumers. And we have invested a great deal of time and expertise in helping Zig through the beta testing phase of our relationship, and we're now moving into the full production phase where we've made a significant investment in this relationship, where we now have particular expertise related to tablet scanners and specifically related to turning your proprietary knowledge into saleable products. And so it only makes sense that during the term of this contract, we be given the opportunity to compete for any new business that's related. And frankly, that's why there is this contractual obligation to do so. We learned recently that Zig has approached another company, Noki, with a very similar product. And this product, instead of being for a tablet scanner, this product would be for smartphones. And quite frankly, the only difference between a smartphone and a tablet scanner is the size. Everything else is the same. And so from our perspective, they are taking the technology that they have agreed we would manufacture for them, and they're now seeking a different platform and outlet for that same technology. And it's very clear under the terms of the contract that we have the right to present a competitive bid to manufacture those new products. So that's why we're here.
Okay.
But,
Thank you.
But actually, just finally, to go back to my initial comment, we believe that we have the right to do this, but we also want to be able to do this because we believe that we will be able to demonstrate to you that we really are the partner you want to be working with moving forward. And we do not want to be prevented from having that opportunity to prove the value that we really offer to you.
Thank you, Ken. I appreciate that. And I'm sure, Sharon, that many of the things that Ken said you agree with and many of the things you might see differently. And so before you respond to what he said, I'd just like to give you the same opportunity to tell me from your perspective how you and your clients see things.
Thank you, Lynn. I appreciate that opportunity, and I also am very hopeful that we can reach an amicable arrangement here today. I think that's really in the best interest of our companies and moving forward. And as you said, much of what Ken has said, I agree with in terms of the background of how we entered into the manufacturing agreement between Zig and Shenzhen. And the beta testing has been going well. We are fully confident that the production piece of it will go well in addition. Where we differ on our perspective on this is what exactly is the nature of what we have entered into with Noki and seek to enter into with Noki. This is not a new product. And the solicitation terms refer to new product manufacturing. The telephone is the product. That's Noki's. That's not ours. So we don't view this in any way, shape, or form implicating Section 7.2 or 7.3 or 7.4 for that matter. This is an independent right that we had. We would not have entered into an arrangement that would have restricted Zig in the way that Ken is suggesting that we would. So we really fundamentally see this as a very different question in terms of what it is that we were seeking. This is not a new product. It is merely a subsystem Noki will be producing the product, that's the phone. And so we don't really understand and don't expect that that's anything that we need to offer Shenzhen to be making a bid on. We didn't need to share Noki's anything that we have had with Noki. And so we're in a position where we feel like we have done every piece of what is required under our exclusive manufacturing agreement. If push comes to shove, I would suggest that what Shenzhen is doing right now is interfering with our right to contract independently. And so, you know, we don't want to go there, much as we don't really want to go here. But we believe that if they were to pursue this kind of a claim, we could come back with a counterclaim that, in fact, it's Shenzhen who is violating our exclusive manufacturing agreement. Again, I am hopeful that there is something that we can work out so that we don't have to pursue these legal remedies going forward.
So before we go back and forth with asking each other some more questions, what is it that each of you hopes to accomplish in our meeting today? Is it something that you want to redraft the contract or just flesh out what the issues are? What are your hopes for our time here today? And I'll start with you.
Well, we spent a great deal of time negotiating and crafting the agreement between the two companies. And I think that by and large, it's serving both of our companies' interests quite well. So there's no need to be redrafting anything. From our perspective, the language is clear in the contract. And from our perspective, both the letter and the spirit of the contract would encompass the kind of activity that ZIG is describing as independent from the contract. So our interest, of course, is to preserve our working relationship because we have a very good one. But from Shenzhen's perspective, we have an obligation to protect our rights as well. And I appreciate what you're saying, Sharon, that you don't want push to come to shove. Neither do we want push to come to shove. And we're confident, first of all, that the interpretation of the contract would fall in Shenzhen's favor. And we're further confident that our right to enforce a contract provision in no way creates any claim for interference in contractual relations with any third party. So I appreciate what you're saying. I respectfully disagree. And we would like to avoid having to fight that issue out, whether it's in arbitration or if it went to domestic court. But we're prepared to do so if we're not able to reach an agreement today.
And again, you know, I feel equally confident that we are not going to be found to have been in breach of any of the agreement that we've made with Shenzhen. So again, it's not where I want to go, but I'm not afraid if we were to pursue this in a more formal setting where there's going to be a decision maker. I feel very confident that the language of what the exclusive agreement, manufacturing agreement, will stand up that what we're talking about with Noki is not a product as was envisioned by that the language and the clauses in the agreement. So, you know, I am hoping, Lynn, that you are going to help the two of us and our companies figure a way out so that we don't have to pursue it. Yes, we both feel confident we could prevail, but perhaps that's not the best use of either of our company's time and resources to go there.
Right, and I agree. I think at the table today, we're not here to litigate the matter. We're not here to dissect the terms of the clause from a judge's perspective. What we are here to do is figure out if there's a way that you can both get what you need. It sounds like both of you have enjoyed the relationship thus far, that the beta testing has been going well. Mm-hmm. Given what you each heard from each other, do either one of you have questions about where things stand in terms of the production of the tablet scanners or the production of the phone scanners? I'm not sure where that is along in the process.
Well, I'm curious, and I don't know whether you have this information, Sharon. With respect to the tablet scanner, from our perspective, everything is moving along well. We had the expected problems, but that's what beta testing is all about, and I think we've overcome them and we're moving forward. What I'm not sure about is what the timing is with respect to any offers that you have received from Noki, and whether that's imminent or whether there is time for us to work this through. My hope is that we are not put in an artificially short time frame where we are forced to play hands that we would rather not play. So I'm not sure if that's a fact question to you, but or more of a statement in terms of our process. I would hope that we are able to play through whatever the mediation process provides or otherwise, so we can reach a resolution before any other external timelines run out that complicate things further than they already are.
Yeah, without getting into the specifics of it, we are able to enter into some conversations today that I think we've got the time to do that. We don't have unlimited amounts of time, but we certainly have some flexibility as of today.
Okay.
So in terms of our time here today, are there constraints in terms of how long you have at the table today so that we can ask a few more questions, or is it something that we need to get sort of to the heart of the matter rather quickly?
Well, we're here to seek a resolution, and on behalf of my company, I'm willing to stay at the table as long as we're making constructive progress. Whether that's 1 hour, or 30 minutes, or a longer period, that remains to be seen.
Okay. So what I heard you say, Ken, is that your company is interested in preparing a bid based on the bids that have been received by Noki. Am I understanding that right?
Well, what we would like to do, I mean, and this is not us, this is the contract. Pursuant to the contract, we have if Zig is seeking to enter into another relationship with a third party to manufacture products similar to the tablet scanner, we have a right to see what they are seeking a bid for so that we can offer our own competitive bid, and to have the opportunity to either meet or exceed the requirements of the bid that they've received. That's all we're asking for, is to be able to do that.
And from what I'm understanding from you, Sharon, is that you do not feel, or your client doesn't feel, that this is a new product that falls under the terms that would require.
Right. It is not a new product, and there's that's really a stretch of any definition that would be a product. This is merely a substructure.
Okay. So hypothetically, Ken, if we go down the line that Sharon is suggesting and we say that this is a substructure, what is your understanding of your client's position about that? What does that look like? If just for argument's sake, we take Sharon's view of things,
okay,
then what would your client expect to have happened?
Okay, well, our positions, I think, are pretty clear. Zig believes that what it is seeking a contract to produce is not a product, and we are very clear that it is a product. My understanding is that Zig believes that what they're seeking a manufacturing for is not a product because it is not the end product, but it is a subsystem. Our view is that products do not exist only for consumers. Products also exist at a wholesale level, and they also exist between business and business. And when you are manufacturing a complex item like a smartphone or a tablet computer or a car, there are many subcomponents that need to go into it, but each one of those is an independent product. So from our perspective, it is in fact a product. So we've done our research. We're confident that a domestic court would find in our favor, but If it were not a product, then I would agree with what Sharon is saying. We're confident that no court would reach that conclusion.
Right. So I feel like we are sort of having the same kind of conversation. It's clear that you both believe very strongly in the position that you came here with today. So I wonder if it might not be more helpful for us to meet independently and see if we can kind of get at what might move us forward.
I think that'd be very helpful.
Okay,
That's
so
fine.
if you don't mind, Sharon, I'll speak with Ken for a few minutes, and then we'll come and get you, and I'll speak to you at that.
Sure.
Okay. So, it seems to me that you're making a request to submit a bid. Is there anything that you can imagine that would be behind their reluctance to either submit for those bids or?
Actually, I'm not sure. From our standpoint, if ZIG has received a favorable bid to produce this product, it would be in their own company's interest to see whether we can do better. And it may be that we can't do better. I don't know, and our company can't know until we're provided with the specifications. And to be prohibited from even seeing the specific terms of the offer they're seeking is preventing us from even participating in the marketplace. And from our perspective, that's clearly in violation of this provision of the contract.
Ken, without having seen the contract or spent as much time with it as you and Sharon have clearly spent poring over it, can you give me a sense of if your client were to be able to present proposals, would then Sharon's client be obligated to go with that offer, or can you just give me an idea of what the process looks like once a proposal is created by your client?
Right. Well, under the contract, Shenzhen does have the right of first refusal. So the way this plays out is that ZIG has the right to seek bids from third parties if it intends to manufacture new products. And after such solicitation, if ZIG receives and intends to accept a written bona fide offer from that third party, and I'll just read directly from it, ZIG shall first give Shenzhen written notice thereof, which notice shall include a copy of the third party offer, and shall set forth all of the material terms and conditions, including but not limited to all of the elements related to price, quantity, and delivery. And then provision 17.4 provides that Shenzhen has the right of first refusal in terms of manufacturing that new product.
Okay. So one other thing that I noticed when we were in our joint session, you mentioned several times how your business relationship was important to you and you perceived it as going very well. I don't recall hearing the same sentiments exactly from Sharon, and that may be that she didn't express them, but is there anything that you can think of that might lead Sharon's client to not have such positive feelings about the relationship? And I ask only to sort of shed some light on what might have brought this to the table.
Right. I'm not aware of anything that may have interfered with a good business relationship. We entered into the original exclusive manufacturing contract with a future relationship in mind, and my sense was that ZIG similarly saw a future relationship. We didn't have any unusual problems as we were working through the beta testing phase of the manufacturing process. And I should add that Shenzhen has invested quite a bit in terms of time and resources to bring their product to be ready for full-scale manufacturing for market. We're now at the beginning of the full-scale manufacturing, and it seems to be going well. Our interest is to continue building on that good working relationship. And so frankly, we're a little bit surprised that Zig would not have given us the opportunity to bid on this new product, and we're perhaps even further surprised that they didn't simply bring it to us in the first place. Mm-hmm. So that's an element that we don't know what's going on, and we would be interested in learning more about.
Is that something that you think would be productive to talk about when we come back together, asking some of those questions?
Well, yes, in the sense that we believe that we bring tremendous value to them. We have been looking for, and we believe we have the potential for a long-term business relationship, and we need to understand more what might be interfering with that developing in a natural way.
I agree. I think that seems to be what I'm hearing, is there's a disconnect between what seems logical to you and what seems appropriate to them. And so I think if we can get some more of that information out, there might be a way to come to some sort of agreement today.
What I'll say, and this should be no surprise, we are certainly confident that we could enforce the provision of the contract. But our interest is not primarily enforcing this contract language. Our interest is in finding out what it means and what is necessary to forge a long-term relationship with Zig. If it turns out that we have no viable future relationship with Zig, then we will be more aggressive in enforcing what we are confident are our contractual rights. But on the other hand, if there is a good faith interest in further developing our business relationship, then this particular product manufacturing piece is less important in the scheme of things.
Well, it seems to me, if you do develop a long-term relationship, you'll want to iron out so that we're not back here with the next, who knows what the next technology looks like, right?
Right. And we want to work with Zig. Okay. We're a large-scale manufacturer. We have a lot of very good customers, and we would like Zig to be one of our very good customers.
Well, before I bring Sharon in, is there anything that you've told me in our private meeting here that you would or would not like me to share with her, or where do you sit with that?
Well, I would like you to, I'll do it myself, but I would be fine with you communicating to Sharon that what I just said, that we value our business relationship with Zig. We believe that we have the potential for a very strong long-term relationship, and that that's our primary goal here. What I would not authorize you to disclose is the relative priority with which we place that in terms of enforcing this contract provision. We stand ready, willing, and we believe quite able to prove this up in court if we need to, but I'm not interested in brinksmanship, and so I'd rather that not be brought out on the table.
So if you just want to take a seat out in the hallway, I'll speak with Sharon for a moment. Thank you for your patience, Sharon. So I've had some time to talk a little bit more candidly with Ken, and I appreciate the opportunity to do that with you as well. Is there anything that you think it might be helpful for me to know in private that might help our conversation move away from the litigation standpoint and into some problem solving?
Well, I don't know how helpful this will be, other than perhaps you might understand a bit more where Zig is coming from and might then be able to help us to see a way forward. I hinted at this when we were all together, and that is Zig is a company that would not and is not interested in being tied exclusively to Shenzhen. So while we're pleased to negotiate this ability to develop the tablet scanner with them manufacturing it, and that seems to be moving along fine, I am not, on behalf of ZIG, we will not and are not interested in closing ourselves off from entering into other arrangements with other companies such as Noki. So to the extent that they view this contract as tying our hands to do that, that's extremely problematic. And that's why I don't think, even if we were to present them with an offer, with what Noki put on the table, I don't think that Shenzhen in any way, shape, or form can meet that offer. So I'm not afraid to present it to them. I, however, am quite concerned about the precedent setting that I am required, that ZIG is required to present this kind of offer, because that is not the contract that we believe that we signed. It is not the contract that we would have signed, and it's not something that ZIG can live with. So if need be, and that's why we're willing to really take this and make it a test case if we need to, because going forward, this is the first of what we anticipate will be many different companies that ZIG is going to be entering into relationships with. And we don't want Shenzhen to be standing in the way of us doing that.
When you say a test case, do you mean that from a litigation standpoint, that taking it to court to see whether your position holds up, or do you mean a test case going outside away from their company? I guess I'm not clear what you meant by that.
Yeah, what I mean is I'm not willing, even though, again, I'm not nervous that they would be able to meet this particular one, I'm not willing to just allow it to go forward and then to expect then that every single subsystem that ZIG develops and wants to negotiate with another company to manufacture, that Shenzhen has the right of first refusal. So in that respect, we need to stand firm on not creating any expectation on Shenzhen's part that subsystems will be part of what they can bid on in terms of this right of first refusal.
So given that, and what you're saying, what I hear you say is that you're interested in keeping the door open to deal with as many different companies as is profitable for your client. Something that I heard in our joint session, I heard Ken say how much his client appreciates the working relationship and the business relationship, and they look forward to a long and prosperous relationship. And I understand a little bit more now why you didn't necessarily reciprocate those feelings. It seems to me that maybe you're afraid of giving more of an impression that you're in this for the long haul, or that exclusive relationship. But is there anything other than the freedom to shop around that would make you hesitant to work with their company? Is there something that's happened along the way, or something that might help them to understand why you're wanting to keep your options open, so to speak?
Well, I'm going to answer this in two different ways. One is ZIG's corporate model and how ZIG operates. We will always want to have the ability to negotiate with a variety and to work with a variety of companies. I think it's just bad business practice for us to be so closely linked in that we only have one partner. If something were to happen to that one partner, that would bring us down. So, as a practical matter, it's unrelated to Shenzhen could be the most fabulous partner in existence. We still would want that ability to negotiate and to contract with a variety of companies, and not to be solely tied in with one. Having said that, the other piece that I will share with you is the relationship has been not perfect. Yes, the beta testing has gone well. Yes, we expect to be in full production, and it's not a terrible relationship. But what I will say is that it has been, Shenzhen's a bit more bureaucratic than we had anticipated, and dealing with some of the issues with being in China, and dealing with some of the issues around the government, et cetera, have been somewhat challenging to us. So, not entirely unexpected, but it has created some challenges.
Okay. Well, what I heard from Ken is that his client has obviously invested a lot of time and resources in the testing and the soon-to-be full-scale production of these scanners. And so he feels like there might be some value that your client is missing in what they can offer in their proposal. And so I wonder if it would be helpful to bring you both back together and see if you can explore the relative value that you can both bring to the new product and any subsequent developments that you might have. It's just something for you to think about. Before we get back together in a joint session, is there anything else that you think would be helpful for me to relate to Ken or for me to understand about where your client is at this point?
Well, I am certainly willing to listen to Ken, but I will share with you, we are not in a position, we believe that we have a very, very good deal with Milky, and we are quite pleased. This is a company we have wanted to enter into a relationship with and begin to work with, so that's something that I intend, Zig intends to go forward with. There's really nothing at this table that's going to change that contract from moving forward.
Okay. What do you suppose, I expect that you don't necessarily want to share that decision with Ken today. What do you think would be the response from their perspective if they knew that information?
Well, as I said, on this particular one, I actually don't think that they could make as good an offer in any way comparable to what Nokia has put on the table. But I also think that this raises a fundamental lack of meeting of the minds, if you will, when we entered into this original contract. Because it's clear to me that from Zig's perspective, and someone else in the office negotiated this deal, it wasn't me. From Zig's perspective, we never intended subsystems to be considered to be part of this. So it's not that we've changed our mind, that we're trying to wiggle out from something. No, this is in fact what Zig has always, because their company has always held this as our business model, that we would have a variety of partners. So I think it would be important for Shenzhen to understand, however we resolve this particular issue, that going forward, we will be negotiating with others. We never intended to be handcuffed by that right of first refusal. That's really about product, and again, even though it's written more generically, it's not exclusively the tablet scanner, but really it's of that ilk. And in Zig's mind, there isn't anything else that we produce that is of that particular ilk. That's a product like that and not a subsystem.
So do you think it would be helpful today to explore the meaning of that contract, or is it more productive to focus on what to do about this Noki contract? Or is that something that we need to discuss between the two of you? I tried to get at that earlier and got sort of stuck.
Yeah. I think that we probably need to have both conversations.
Okay. Is there anything other than essentially the decision to move forward with Noki, which I assume you want to remain confidential?
That's correct.
Anything else that you've shared that you don't want me to share with Ken when he comes back, or?
I'm actually not sure that there's much that I really want you to share of
Okay.
what we've talked about
All right.
with him. I think in generalities, but I think you can look to me for what it is that I want to share
That's perfectly
and
okay.
when.
Okay, perfect. All right, well, we'll bring him back in and we'll see where we can go from here.
Hello.
Hello, thanks for giving us some time. Well, I have a better understanding, having spoken with the two of you, about where this is going. I'm not sure whether the two of you might not want to share some of the things you shared with me with each other. It seems to me that there are two fundamental issues that need to be resolved today. The first is, what are the two of you going to do about this Noki offer that's out there, whether or not your company will have the opportunity to respond or submit proposals on that. And then I think moving forward, it's going to be important for your two clients to have a better understanding about what sorts of products fall underneath this right of first refusal contract language, because it's clear that's what brought us here today, and your interpretation do not seem to get to the same answer. And so I think maybe we don't need to rewrite it, but we need to have a better understanding. You two need to have a better understanding of what it is that is covered under those terms. So I leave it to the two of you to decide what's more important to you today. Is it more important that you resolve the immediate issue of the Noki contract, or would you rather spend the time talking about, in the abstract, what is it that we really agreed to?
Well, I guess I would like to know from Sharon what Zig's view is in terms of a long-term relationship with Shenzhen.
Fair question. We are assuming that the full production goes as we anticipate with the tablet scanner. We expect that relationship to continue, and we don't see any particular reason why we would remove that business from Shenzhen and take it anywhere else. So
That's
again,
good news.
good. I'm glad you think that. We currently have a 1-year agreement, and so again, assuming that we stay on track with all of that, we would entertain continuing that agreement going
Okay.
forward.
Okay. And so if Zig sees, and by the way, I appreciate hearing this, and I know, because I've talked with my principals, that Shenzhen has the same view in terms of looking to Zig as a long-term working relationship. We see it as a partnership, and quite frankly, as fitting quite well in terms of our own long-term business plan, and we believe that we will continue to bring strength in this area. And frankly, we're confident that you would not find a better manufacturer for the technology that you develop. If we see promise in this relationship, separate from the language of the contract, my clients are a little bit unclear why you would not even entertain the opportunity for us to bid on further business.
Well, I think here is where, and I mentioned this when we were all together, and so let me say it a bit more explicitly. Zig's business model calls for us not to tie ourselves exclusively to one manufacturer. That, as a company, the policy that the company has always undertaken and philosophically believes that it would be just a bad decision for us to be so closely aligned that we rise and fall with another company. And as a result, we want to have a strong, good relationship with Shenzhen. We see that the future in terms of this tablet manufacturing, and we would like to be able to work with other companies in terms of other systems that we do. And it doesn't matter how fabulous Shenzhen is, we would still believe that.
Well, I appreciate that. And I guess it's important to say that that's something to have been negotiated at the front end of the exclusive manufacturing. That the nature of our business relationship was defined at the front end. It's unfortunate that we're needing to define or redefine it here at the table. And it's also unfortunate that neither of us were the agents at the time that the contract was drafted, so we don't have that individual history. But be it as it may, well, two things. Number one, what you're saying makes perfect sense. It's very clear that as much as we value Zig, you're not our only client. We work with many companies, and it makes perfect sense that you, as a growing technology company, would also want to work with a variety of business partners. But again, that's something to be addressed at the drafting stage of a business agreement, not at the point where the four corners have already been defined. And so, as we see this contract, it's pretty clear and straightforward that, at least in terms of scanner technology, and specifically the kinds of things we're working on together, that this is not only what was intended under the contract, but this is in fact what the contract said. Now the reality is, we want to continue doing business with you. We are willing to be flexible as we address how to deal with the Nokia situation. If there is a realistic prospect that we will have an ongoing business relationship. It sounds like that's true with respect to the current contract. I would like to hear some tangible assurances that that in fact is true in terms of other business areas, because frankly that's going to influence the strategy that we pursue moving forward.
I sounds a bit like a veiled threat to me.
No,
However,
not at all. I'm being honest with you.
Okay. Well, first of all, I agree that this is something that should have been more clearly defined. I think what may have happened that our counterparts chose to live in the ambiguity and allow to exist these two competing ways of interpretation. Because as I read the contract, I can read it so that it seems perfectly clear to me that we are not in breach. And so I think that we will have to agree to disagree about who the contract on the face of it.
Okay.
Because I actually don't think that it calls for us to have shared any of that with it. It's not a product. Be that as it may. I think that we certainly can go forward in terms of the tablet scanner. I think that as technology evolves, the tablet scanner is eventually going to be passé, and there will be something else that comes on. And I think that Shenzhen, again, assuming that the production goes as we all anticipate it will go, and the relationship continues in the way that we anticipate that it will, and we've worked out all of these other things, that as things change, Shenzhen, once again, may be someone who we would like to bid a new piece of, a new product with. I can't say exactly, it doesn't foreclose it in anything unless we have a real major breakdown over this issue. So in that respect, yes, I think that we can be talking about some ongoing, continued ongoing relationship. So long as Shenzhen understands, just as you said, that we are not your exclusive company you work with, that you will not be the exclusive company we work with.
We were
technology.
very clear about that. And frankly, coming full circle around, maybe this is to use the expression, the elephant in the corner. We have not been privy to the specifications that we're talking about in terms of Noki. And this may be a tempest in a teapot.
Mhm.
Were we presented with those specifications, we might have looked at that and said, that's not our business.
Mhm.
We don't do that.
Right.
But we have been prevented from even making that assessment. And so perhaps what would be helpful moving forward is for us to exchange that information so that we can see it and see whether, in fact, it continues to be a problem or is not a problem. We're confident that if it's not something we produce or a direction we choose to go, we're not going to try to compete for something that doesn't fit our own business model. And so there's no problem there. If it is something that fits within our business model, it would seem to be in your best interest to be able to evaluate competing bids for your business. And so I don't see a downside there. Perhaps for purposes of this dispute only, and without waiving any other rights or any inference that we are rewriting the terms of the contract, that we would look at this as a one-off where there is not a right of first refusal by Shenzhen. That we would look at it, we would talk together, and we would determine whether this is a product. We would, if it's appropriate, we would make a bid, but we would not insist that we have right of first refusal as to this product. I also think it would be helpful as a preventive measure moving forward for us to engage in further conversation to more clearly define what this language means that's ambiguous. I don't think it's helpful to either company to try and define that language while we're in the middle of a dispute, because, as you've said, you have your interpretation, we have ours, and I don't know that we're going to find a meeting of the minds on that.
Right.
So I would propose a two-step process. Number one, you provide us with information on the Noki bid and give us an opportunity to look at it and to present under the terms of the contract. We have 30 days within which to present our own offer. We would not claim to enforce any right of first refusal with respect to this one piece. And then you would either accept or not accept whatever bid we propose if we present it. And then once this is laid to rest, we then agree to meet and reach agreement on the interpretation of that contract language.
I like the direction that we're moving on this. I think that makes a lot of sense for us to try to bifurcate this. And I am willing to entertain as a one-off in terms of not precedent setting, not pursuant to the contract, that we would share this bid with you and give Shenzhen an opportunity to put in a proposal. It would actually, therefore, if it is possible to agree to a different term rather than 30 days, do you think that Shenzhen would be able to produce a response within 15 days? So then it would be clear that this is not pursuant to the contract. This is two companies that are exchanging information.
It's hard for me to commit on behalf of my company that they can produce a bona fide bid in 15 days when we don't know what the specifications are for that bid, although we do work quite quickly. It sounds like what you would like to achieve is some signal that this is not pursuant to the contract. And if it were a 30-day period, that it would appear to be pursuant to the contract. What I would propose is that we make this review period 25 days. It's constructively the same amount of time it would give my client the time to do whatever research and work that they need to work it up, but it would also signal that it's not under the terms of the contract.
Right.
I'm not, well, I'm not authorized, I've not been expressly authorized to reach that term, but I am confident that if I bring it back to my client, I can persuade them in very short order. Maybe as simple as a phone call to that. But I think that meets your need of making it clear that the agreement we would reach at the table today is not an interpretation of the contract, but is in fact a settlement of a dispute.
And in fact, Lynn, I don't know if in the written terms of the agreement, if perhaps we could even have language to that effect, that that we will be sharing this bid and that it is in settlement of this dispute and not pursuant to any term of contract. Is that acceptable?
Yeah, as long as ZIG is in fact will make a good faith effort to review whatever bid we present in the event we choose to present one, then there's nothing more that my client would want, because frankly, we're a very competitive company, and when we choose to compete on a market, we're successful. So we will stand on the quality of what we present rather than leverage.
And let me also just make sure that we don't have any misunderstanding. ZIG is under no obligation to accept the terms.
With respect to this one disputed issue, yes, that's correct.
Right, so the bid will come in, it will be reviewed, but ZIG is not under any obligation to accept this bid.
Yes, and I just want to make sure that we're clear. It's correct that ZIG is not under any obligation. That would be tantamount to a right of first refusal.
Right.
And ZIG is representing, or you are representing on behalf of ZIG, that this is not a pro forma review, that this is in fact a good faith review of a business offer that we would be extending should we choose to do so.
Yes, it will be a legitimate review, and again, I want to be upfront, and I don't want to be misleading in any way. There is a strong incentive for ZIG to enter into this negotiation, into this agreement with Noki. And so it would be, is it impossible to break that? No, it's not impossible. I mean, sure, maybe there is a reason why ZIG won't do it. But I will say that there is a strong likelihood, given ZIG's business model and given what ZIG is trying to accomplish, that the Noki bid will stay with Noki. So I don't want to mislead you.
No, I appreciate that. And what we are looking for is an above-board, good faith relationship going both ways. On behalf of my client, I am offering something in settlement that we believe we are not obligated to offer. Mm-hmm. In fact, we are offering what we would consider to be a compromise that is unnecessary. You perhaps have a different perspective.
I would view that what we are offering is equally that.
And so what we're looking for is recognition that we're making this effort because we believe that there is potential in our future business relationship, and that we want it to be a constructive relationship and not one where we need to fight.
And I agree with that. I do agree with that wholeheartedly.
Okay.
And on behalf of ZIG, I know that that's what they believe to be true.
Okay. So this is good news. What I'm hearing is that there are several agreements on the table today. First of all, you're agreeing to honor the contract with the tablet scanners and fulfill that one-year contract with regard to that particular manufacturing process.
And I'm hearing that there is a prospect that will continue beyond the 1 year.
Correct. Then in terms of the short term, for the purposes of this one Noki contract dispute, there will be an agreement drafted that says that your clients are able to produce an offer based on the specifications that they get when they review the Noki offer, and that ZIG is under no obligation to pursue the offer, but they will evaluate it on a good faith basis, and you will do your best to provide a competitive bid.
Mm-hmm. If you're able to provide it. I mean,
If we may choose not to.
Correct, and that you have the option to decline to even present an offer.
Mhm.
And then at some future point, the two of you will sit down and draft a better version, a more clear version of what you think this contract should and arguably did say from the onset. Is that right?
Yes.
Okay. Is there anything else that we need to talk about before we wrap up here at the table today?
Well, I would be happy to offer to draft the agreement pursuant to this mediation and send it to you within the next 2 or 3 business days. I think it'll be pretty straightforward.
Mhm.
I do need to go back to my client and confirm the 25-day period, and that's not so much in terms of a legal issue, but really a technical issue, whether in fact the technical team would be able to prepare a bid in 25 days. I'm pretty confident they can. I can get that answer to you by the time I present you with a draft.
Okay,
But I'm confident that I can persuade them to.
that would be fine.
Okay.
And from your perspective, Sharon, anything else?
No, I think that addresses it.
Great.
Well, thank you for your hard work
Well,
today.
Thank you.
Thank you. Thank you very much.
Thank you. Thank you. Nice to meet you.